Industrial Revolution, it became a fact that the world was going to change. The acceleration of the global production became a phenomenon never seen before by humanity. Cities and towns all around the world started advancing at their techniques and at their economies. In that way, the world turned to be ruled by the economy. This went even further when the globalization process appeared and augmented its velocity year by year, erasing more and more cultural walls and making every place on Earth connected. Under this narrative was that the United Nations organized itself to turn out with a general agreement for every member of the organization to accept it, regulating the international commerce with straight-ahead rules so everyone could understand and develop themselves without advantages and unfair plays, referring to the economic and political terms. The result of this reunion was the United States Convention on Contracts for the International Sale of Goods, happening the 11th day of April from the year 1980. As said, the intentions of this convention was to provide a modern, uniform, and fair regime in which contracts for sale of goods internationally could be negotiated and applied all over the world. By this, the plan of the convention members was to facilitate the interchange of goods between countries and to reduce the transaction cost originated on politics and bureaucracy.
The relevancy, even nowadays, of such international agreement was the impact on trade agreement law, permitting the advancement of economics from some countries to expand in easier way over their frontiers, standardizing some processes and products, up-leveling the whole quality of goods available all over the world. Equally, it represented an opportunity of growth for every country, especially talking about the medium-sized companies, which had a special opportunity of expansion seen clear on the German economy that sustains itself based on these companies, representing such key business global that most of our product Norways had been made or manufactured with products made by these country companies, such as the case of Desma Shoe Machinery, a German shoe sole making company which produces almost a large amount of shoe soles for all the shoe market offered worldwide. If you want to know more about this success case, you could check Visualpolitik videos on the topic ¿Por qué Alemania es una potencia industrial?, in which they present the case more in depth.
Anyway, going straight to the point, the United Nations Convention on Contracts for the International Sale of Goods, also known as the CISG by the acronym produced by its last four letters initials since January 1st from the year 1988, had the function to regulate the contracts for international sales of goods between private businesses, excluding sales of services, and some protected goods. On that sense, the Convention helped with the standardization of the processes, also protecting international private businesses, establishing ground rules that the international community recognized. making more difficult for corrupt officers to act on untruthful terms with them, serving as a warranty for the opening of the local markets to the global community. Today, the SISG has been an agreement ratified by 94 countries, including Mexico, and signed but not yet ratified by 2, which are Ghana and Venezuela. On that term, these countries agreed on basically 4 main points or parts, which are specified by the UN agreement.
On its first part, titled As a Sphere of Application and General Provisions, on its 13 articles clarifies that this agreement exclusively applies to contracts of the sale of the goods that are celebrated between two parties whose business are in different states, referring to states as a country or range, not a province. Also, Part 1 specifies this agreement are applicable even when the contracts enter on a controversy due to the application for the law of a contracting state. In that sense, this part of the agreement recognizes that its interpretation belongs inside the international character. In other words, depending on the level of recognition of the international law on the state's formulation, this law may be over or under the national constitutions of the disputed country. But also to have clear that the recognition the country gives to the agreement will represent the level of recognition of the international community of the good will of the country to open itself to international commerce, meaning this will determine the relations within the country and the international community. All that said, it also recognizes that its formulation is not perfect, so any gap presented should be filled by the national law of the countries involved, giving them the freedom to determine its local market.
Passing to the second part of the fourth, titled as Formation of the Contract. Applying over the 14th article to the 24th, this part talks about the nitty-gritty of the contract formation, specifying every part shall count with a sufficient amount of goods, quantity and price to make an offer and establish a contract, or at least to have a document which proves the seller is able to pay the amount. Produce the goods and send them. Also, it recognizes the right to revoke and offer a contract just before or at the same time the offer is sent or when the offeree has not yet set the acceptance of the offer.
The third part, on the other hand, is titled Sale of Goods, and it covers the 25th article to the 88th article, specifying all over those sections the sale goods included and excluded from the agreement, obligations of the seller, the obligations posing of the risk, and obligations that both seller and buyer share when establishing a contract on the terms specified by the agreement.
Finally, the fourth and last part titles Final Provisions, covering Articles 8, 9 to 101, clarifies some reservations and declarations, including exceptions and extraordinary cases in which, for example, two states are concerned by one term or law, equal or similar, or some specific subject. This part characterizes itself as a difference from the other three parts to be addressed exclusively and primarily to the states than to the private business. Nevertheless, this part tries to be applied into such a broad area that it looks short against the actual situations, causing it to be controversial while solving problems. corresponding to the convention's interests.
When exploring this topic, it is important to clarify SISG only regulates international transactions of the sales of goods, not trying to apply a normative structure to domestic sale of goods occurring on any country, leaving this to the existing domestic law, even nowadays. On that words, finally we have reached to the end of the topic, crossing briefly inside the main points of this convention, learning how its agreements formed our present global market, permitting the huge system on importations and exportations all over the world, uniting us in a whole one market.